disability discrimination, which arises from problems in education, educational negligence, which is more commonly known as a failure to provide a child with the right type of education. But today, given the focus of this conference, I want to look at SEN and exclusion in particular. So just to get an idea of what SEN is defined as, under the Education Act 1996, which is a huge piece of legislation in terms of education rights, it's defined as a learning difficulty calling for special education provision, which is massively wide. And in your books, that's a really positive thing, because the wider the definition, potentially more children can fall into it and are covered by the safeguards which go with SEN. A learning difficulty is defined as having a greater difficulty in learning than other children, so a greater difficulty learning than children's other non-disabled peers. And special education provision is provisional to or different from education made for others. So it's when somebody needs some kind of support which is additional to what they would usually get in that education setting. So lots of people fall into this. SEN can cover physical disabilities, mental health problems, mental disabilities, and it's thought that 1 in 5 children at some point during their school years will have SEN, so it's massively wide. And the North West is thought to have the 3rd highest sort of ratio of children with special educational needs in the UK, so it's also quite topical given the geography of it all and where we are today. Looking back at when the SEN system was set up, it all stemmed really from the Warnock report, which was back in the late 1970s, early 80s, when statements were introduced as a kind of tool really to get children with SEN and get them through the education system as well as possible. And in 2009 the Lamb inquiry was held, and this looked at where we'd come from and how we can raise parental confidence in the system and how best we can do that. So there have been lots of attempts, and we've made huge leap forwards in terms of recognising that different children have different needs, but it's where we take that really how it will determine the future. As you'll probably be aware, there's this green paper which is currently being looked at, and the green paper is like an initial stage when the government are looking at changing guidance and changing legislation to see where that will go. And there's various points in this paper which they're looking at changing. One is replacing the statement process altogether with a education, health and care plan, which will run from when a child is born up until the age of 25, so it has a much wider application. And the idea is that everybody will work collectively together, whether it's social services or local education authority. But in reality, how that will run, we have lots of problems just trying to deal with local education authorities now. So if that can't be fixed and put out now, we're not sure how it will all merge together. Improving parents' choice of school. They're looking at early intervention, so children sort of 2 and 3 years old being assessed to see if they have special educational needs before they get into mainstream education, so systems can be put in place for them. Personal budgets, which I know were touched on before. This is sort of giving parents the power to choose what services their children need rather than the schools not funding, but the schools putting them in place. Lots of parents would like this. They'd say, fine, give me the budget for my child and I'll ascertain what services they're going to get. But in reality, I think parents have quite a tough time anyway, just trying to navigate through the system. And perhaps if the school's expertise is in providing educational provision, that should stick with them. And the roles should be distinct. So lots of people have seen personal budgets as kind of just shifting the burden off the school and putting something additional onto parents. There's going to be greater emphasis on mediation, so rather than there being a problem at school and following that through, it would end up in the tribunal system, for example. They want to make it so mediation is really used to try and solve these things. Again, sort of there's positives and negatives for all these things, but that could potentially just slow things down and give the schools additional time and longer time for problems to linger. So just looking at it different angles. there's also going to be a right to appeal for children themselves. Because at the moment, you can only go to the tribunal if you've got parental responsibility for somebody. So sort of children over the ages of 16 might be left out of that process. But I think that's probably a positive thing because it makes schools more accountable if they know that they're answerable to not only parents but children as well. And you might have seen recently in the news that they're proposing to redefine what the special educational needs definition is and trying to effectively sort of pull it into one place, which makes you think, given sort of recent budget cuts and things like that, whether they're trying to only catch the people with the most visible needs really and leaving lots of people with special educational needs who you wouldn't necessarily know have those needs unless you spent time with them out of the picture. At the moment, and looking at the here and now, and this is obviously important to all of you because you've got to work with what you've got at the moment. The system is governed through legislation, so lots of different pieces of law, different regulations. Many of you will have heard of the Code of Practice for Special Educational Needs, and that guidance, although it's not law, it's got very strong standing, and schools would be heavily criticised if they weren't adhering to that guidance. And overall, the local education authority has two main duties towards children, and this is to promote the fulfilment of a child's education potential and to safeguard and promote the welfare of children, which kind of stems back to what Richard was saying before with the Children Act, the welfare of the child being the paramount influence. So the special educational needs stages. If you think your child might have special educational needs, you can request that the school and the local education authority, who should work together, assesses that child to see whether they have any additional needs which can be identified. The parents can request that, and likewise the school can. So it's a two-way process, and each of you should be fully informed of what's going on and notified if there's any assessments taking place. In the early stages, when children are very young, early intervention can be used, and that's kind of seeing whether they have any obvious additional support needs. You can then move on to school action, which is recognising that additional learning material, for example, or additional time, having to write answers down rather than the set time other children would get. Just those kind of initial leeway arguments. School action can be really useful for that, and it is documented. Failing that, you can move on to School Action Plus, which is often where external agencies are brought in, for example, a speech and language therapist or an additional teaching assistant to help that child. And if none of those work, or they work with limited success, then statements are your final sort of remedy really in trying to get your child's needs identified. And I'll move on to talk about the statementing process a bit more. School Action Plus and statements are the stages, that's what they've been named at in any formal documents. But on a more informal level, each child who's subject to one of those three should have an individual education plan put in place. And that's kind of a more day-to-day document, identifying needs, what can be done in the classroom every day to help that child, how much assistance they will have, what happens when they're out during break times, do they need to be assisted, those kind of things. So that IEP is really important, and it's a really, really good tool for parents to see the contents of, to see if you agree with that. And this is what it should be reviewed 3 times per year. If you're in the earlier stages, it's usually reviewed between 8 to 10 weeks in early intervention. So it's a document which should be kept well up to date with your child's needs and development. In this case, Tyneside in 2010, it was held that statements are binding documents, they're legally binding, and I'll talk about that a bit more in some detail. But the local education authority has to provide what's set out in a statement, regardless of whether they say, which they often do, but we've tried our best, we've put all these things in place, it's still not working, there's some other problem. It was held in this case that there's no best endeavours defence. It's not good enough for them to say we've tried everything, and they're legally allowed to give those children what it says in their statement. So this is really a good one just to note in terms of how broad. So essentially, in terms of inclusion, disabled children should be given the opportunity to learn as their peers would learn in an environmental setting. Special educational needs coordinators, they have to be assigned to primary and secondary schools, and it's usually one teacher who has the role of looking after children with SEN, seeing how they're working in the classroom environment. If they've got any problems, it would immediately be the SENCO who you would talk to get things going. Essentially, it should be the school who meets any children's needs in terms of special educational needs. But once statements are put in place, the local education authority are much more involved at that point, because it's their obligation to put that provision in place as opposed to the school. So it shifts a little bit of the focus between the school and the local education authority. I don't know how many children have got statements, but it's usually split into 6 parts. So the first part will have kind of name and address, date of birth, all kind of factual information. And then the second part will outline children's needs. So it will say what their medical conditions are, what their disability is. Part 3 should identify what provision they need in the classroom because of the needs identified in part 2. So that's really important. And part 4 will often name a school where that child's to attend. Now all those sections are binding on the local education authority. If it says a particular provision needs to be put in place, and if it names a school on the statement, then it has to go. And if that fails to be adhered to, then that can be challenged legally. But they have to go with that. In parts 5 and part 6, these are often non-educational provision and non-educational needs. For example, speech and language is often put in those parts of the statement, as would be physiotherapy if a child needs that on kind of a weekly basis. And sometimes you'll see that the local education authority is keen to fill up parts 5 and 6 and will leave parts 2 and 3 quite empty because they're not legally bound to provide 5 and 6. If you manage to shift it up and put it in parts 2 and parts 3, then they're legally bound to provide it, and that's what they'll often try and move around. So when you're sent a statement, a proposed statement, which should happen, you should all get a chance to see that, that's worth going back to them if you think things should be bumped up and they should be higher. In terms of process and timescales for statements, I've worked all through this in those details, but generally, from a request being made for a statement, and a request for some kind of assessment to see if the child needs a statement, to a statement actually being issued, it shouldn't be any longer than 26 weeks. And that's not a target for the LEA to run to, it's a maximum. So ideally, things should be resolved a lot sooner than 26 weeks, but that's absolute maximum. But what you'll find in practice, you're not made aware of these timescales, so they'll often run on. And so then you can see children sort of stuck without any adequate provision for months and months. So that's worth bringing to the LEA's attention if they're dragging their feet a bit. Hopefully you would be able to talk to the school, talk to the LEA, and negotiate and discuss your child's needs, and you would hope that they would take that into account. But by the fact that you're all here today, and from everything you've heard, you know that's not the case. And unfortunately, some issues get too big for the scope of sort of complaints and negotiation, and that means they would run to the tribunal. And these are the kinds of decisions the tribunal can deal with. So if an LEA is refused to assess in the first place, if they refuse to make a statement after an assessment, the contents of the statement, so when we were talking about what part 3 and part 4 would say, if you dispute that, then this could be an issue for the tribunal. If there's issues with which school has been named, or if an LEA says, right, we think your child's had a statement for this amount of time, we don't think they need it anymore, and they want to cancel it, then that can also be brought into the scope of what the tribunal can deal with. And as of 2010, once a child has an annual review, if a LEA decides not to make any amendments, contrary to what the parents want, you've got a new appeal right to take that to the tribunal as well. So that's always a useful one. And with any of these, you've only got 2 months to appeal, which is really crucial because you'll often get the decision letter of what they've said. We've decided not to implement the statement, or we don't think the child needs an assessment. And lots of parents won't be aware that that's time limited. You might think, we can complain about that at a later date. But if you want to take it through the tribunal, you have only got 2 months from receipt of getting that decision letter from the local education authority. If an appeal is upheld in the tribunal, generally the LEA will be ordered to do what the parents wanted them to do in the first place. And the tribunal will really frown upon a local education authority or a school if they've been seen to waste any time, or if they feel it's been really unnecessary to drag the parents through the tribunal when realistically matters could have been dealt with way back. And so they could be heavily criticised for that, not something the school wants to be criticised for, and costs in any cases can be, they can be awarded against each party, to be fair, but often a tribunal is reluctant to make parents pay, and it will be the tribunal, it will be the school or the LEA will come down heavy on. If an appeal is dismissed in the tribunal, you can appeal back to the upper tribunal, but that's not an end fact of the case. That would just be if there's been any errors in the way that the judge has applied a particular law. So that's kind of a separate issue, but there are routes to go through the appeal. Just moving on to exclusion. This can be either on a fixed term or a permanent basis, and I'll focus on permanent for now. With the Lamb inquiry back in 2009, it was held that children with special educational needs are 8 times more likely to be excluded from school, which is a huge amount. And exclusion should only be used if there's been a serious breach of a school's behaviour policy. So the most obvious ones you can think of are a child taking a weapon into school, or getting into serious fights and things like that. If they've breached the behaviour policy, or allowing that pupil to remain would detriment the education of others. So they're the only instances when exclusion should be used. But in reality, when looking at the statistics above, you can see that what often happens is children just get too difficult for schools to deal with, and it's much easier for schools to say children with SEN, they require additional support, they need more resources. Let's just take them out of the school system and remove the problem as they see it, which is unfortunate, but what we see quite a lot. And schools should also be aware that if you're going to do that, not only could it be an illegal and an unofficial exclusion, you're also facing disability discrimination claims if you can show that you're acting that way against a particular pupil because they've got special educational needs and for no other reason. And they're separate proceedings which can be brought, so that's also quite useful to have in the back of your mind. If a child is excluded, the head teacher has a duty to inform the parents straight away, so that the same day the parents should be notified that that child has been sent home. And then they must speak to the governing body and the LEA straight away, so everybody involved with that child knows exactly what's happening. The governors must then meet between 6 and 15 days following the exclusion. And there's nothing wrong when you're going into any meetings with schools or head teachers to ask for somebody to go along with you. They might not like it, but it's your right to do that. And to write notes, I always say go in, take a pad of paper, spook them a bit by the fact that you've got some paper, and just make notes so you've got a record of exactly what's being said. And that's much better than just having conversations with people, because things can be twisted, or you'll think, did I say that? I can't remember. So it's always best just to have a written record. For the first 15 days of an exclusion, the school are obliged to provide work for that child at home. And after this time, it falls to the local education authority to provide the education. So again, it's the LEA and the school working together, which should happen. the governor's meeting, after the exclusion, there's this governor's meeting. The governors might want this child back in school, and away you go, that's what you would want. If not, and they say no, we agree with the head teacher, this child should be excluded, then there's a thing called the independent appeal panel, which is the next stage, which, as the name suggests, it's independent, it's not part of the local education authority or school, it's a separate body, and it will hear cases in relation to exclusion, and it can recommend that a child is reinstated. I think from September this year, they're looking at replacing these with independent review panels, and that will take away the power to reinstate a child at school. So it's kind of narrowing down in terms of what the panels will do. And ultimately, as Richard discussed before, a judicial review can be a remedy in exclusion cases and admission cases if all of this fails to work out. In this guidance, which was published in 2008 from the Department for Education, it states that other than in exceptional circumstances, schools should avoid permanently excluding pupils with statements. So children with and without statements are differentiated against in terms of exclusion, and there is a keen sort of bias to keep children with special educational needs in school unless there's really compelling grounds not to do so, because it's recognised that it can have such a detrimental impact, and it can take a lot longer to get a child with special educational needs back into the school system as maybe their non-disabled peers would. What's thought best, if there's an instance where they think this potentially could want us to exclude this child, what you should do is hold a review of the child's statement. You should think, why is this child even being considered being excluded? Something must be going wrong in the first place. Let's have a meeting, let's look at the statement, let's see if it can be amended, or we can put additional provision in part 3, or whether the parents would agree to the child move to a different school, which would change what's named in part 4, and let's see if we can work it out that way, because under no circumstances should a child with SEN just be excluded with no sort of further recourse to know where they're going. As I know Richard touched on this before in terms of remedies, always be open to talk to schools about what it is you want them to do. They will do likewise with you, and you might disagree, and that's when you can go through the complaints procedure. I know lots of parents feel that the complaints procedure is kind of a waste of time, because if you're sending complaints to the school and the head teacher's considering them, the head teacher's the one who you've had the problems with in the past, it's kind of, falling on deaf ears. But it's worth doing it, and it looks good for parents to say they have tried it, because it sort of gives you a bonus point here. You've tried to raise these things. They might be ignored, but always worth to put a formal complaint in and see where that takes you. Failing that, you can go on to the local government ombudsman, who can deal with complaints in relation to schools. So if they are being ignored or they're not being dealt with properly, and failing that, then you would be looking at legal proceedings and judicial review. With special educational needs issues, you've got that 2-month time limit, which you need to be mindful of if you're going to do that. And things like exclusions and admissions, they can be challenged by judicial review rather than the tribunal, and you've got 3 months to issue judicial review proceedings from the date of the decision. As always, we always say it's worth to quote human rights legislation, Article 8, private family life. Obviously, if children are having problems at school, it's going to affect their home life, so it has an adverse interference with that, which is worth pointing out. And under Article 2 of the first protocol of the European Convention on Human Rights, it also states that no person should be denied the right to education, so that's fairly strong and fairly wide, so it's always worth to put down in writing. And that's it. If you've got any further questions, me and Richard are both around over lunch, so feel free to come and ask any questions. If you want copies of the slides, we can send those to you. And at the back of the room, we've put some leaflets in terms of the education work we do and the disability work we do. And if there's none left, come and see me, because I've got some more. And they're my direct contact details. If you want to get in touch, if you've got any questions, more than happy. Okay, thank you very much.